Welcome to our webinar on basic estate planning. Another way to plan your legacy is to make sure that your basic documents are in order. Now, most people are familiar with a last will and testament. The most common question that I get as an estate planning attorney is, I need to get my affairs in order, I need a will. I call that the Hezekiah moment, where Isaiah told him, get your affairs in order, for you will surely die. There does seem to be an element where we all realize that death is coming and we need to plan for it. So certainly a will is an important start, but what we're going to talk about is other documents that should also be considered, because we want to leave a legacy of blessing to the next generations and not leave them a mess. The statistics are actually pretty scary, that 71% of our population dies without doing even a simple will, much less these other documents that we're going to discuss as basic. I believe every adult should have these documents. When my kids turned 18, we did these documents. So you're joining this webinar, or you've seen us on our website because you are already familiar with our ministry, which is to advance religious freedom, sanctity of human life, protection and advancement of the traditional family. So we do thank you for supporting us. We thank you for your interest in our ministry. And so we hope that these tools will be useful to you to help you leave a legacy to those around you, to your loved one. So why do we do what we do? Well, quite simply, we just couldn't stand by and watch secular lawyers and judges make decisions from the bench that affected our religious liberties. So Liberty Counsel was founded in 1989, and so that we are trained to go into the courtroom and fight for religious liberties and fight for Christian causes in the courtroom. In history, many decisions were made without even considering the Christian worldview because we were not even in the courtroom. So we thank you for supporting our ministry and advancing those causes. But just like missionaries, we are limited on resources and therefore need to pick and choose which cases we will enter, because we simply don't have enough resources, don't have enough lawyers and paralegals and staff to show up and make sure our worldview is known. So we do appreciate your support, and thank you for helping us in our mission. The key to this is that we are all philanthropists, meaning we can't take anything with us. Everything that we have will stay here when we die, when we're called home to be with the Lord. And so we want to make sure, as we manage God's resources for this short amount of time, that we do it in a way that honors him and leaves a legacy of blessing to our friends and our family and future generations. Many of them may not even know who we are, but we can show them what we believed and what was important to us by doing good planning that hopefully will be carrying on to future generations. So we are not in a marathon. We don't just get to keep everything that God has blessed us with, but instead life is a relay race, and we as stewards are simply preparing the next stewards to be wise stewards of what God has entrusted to us. A good estate plan, we're not just doing it to make sure that our money goes where we want it to go, but we are doing it to provide family harmony. Many people are shocked at how families fight over money when we die, but if we have everything in writing, then it makes it a lot harder for other people to intervene and mess up the plans that we have. So we want to make sure and have a good estate plan, and we want to make sure that everything is very well documented, so that if it goes to litigation, then there is a very slim chance of success, because we have created a plan with wise counsel and we have documented that plan in a manner that's legally enforceable. So these are the documents that are included in a basic estate plan, and we will go through them one by one. And so we want to look at all of these, more than just a will, as you see, but there are other considerations which we'll talk about in this webinar. The main things that we're doing in a will is we are determining how the assets are distributed upon your death. You are nominating the person in charge. I practice law in the state of Florida, and here we call that person a personal representative. Other terms that other states use are executor or administrator or fiduciary. Other things that we can and should do in a will, sometimes the next generation is not ready to receive our resources in a wise manner, so that we can name guardians, we can set up minor children with guardians and make sure that they have the best chance of succeeding and not receive these resources before they're ready to receive them. So in addition to the will, we also need to discuss and consider a durable power of attorney. This is good while you're alive and appoints someone to manage your business and financial needs while you're alive. The moment you die, this goes away. Now, if you have a power of attorney in place, then you want to be aware of the date of October 1st of 2011. That is when almost all states completely revised their powers of attorney. And so if you have an older one, you want to make sure it's up to date and more readily acceptable. You also want to consider a healthcare surrogate, and this is increasingly important as, not to get too political, but sometimes we see our medical community or the CDC making medical decisions that you may disagree with. You may or may not want to take an experimental shot. You may or may not want to do chemo or radiation if diagnosed with cancer. And if you do not have a surrogate who knows what you want and is in line and ready to fight for you, then your chances of having your wishes carried out are diminished dramatically. So you want to have a good advance directive of your healthcare preferences, and you want to name a surrogate who knows what you want and is ready to step in and fight for you. And sometimes the right answer is to consent to the medical treatment being recommended, and other times the right answer is to refuse consent. But the bottom line is we want it to be your decision and not the decision of the doctor or the medical staff, whoever comes into play. Another key point is that as long as you have mental capacity, you are able to make your own decisions, and this is only effective on your incapacity or your inability to give informed consent for whatever is being recommended. Also, what we include in the healthcare surrogate and recommend that goes alongside with it is your living will. Your living will is where you give your end of life preferences. So when death is imminent and they're trying to make the decision of whether to continue artificially prolonging your life, then you want to make sure your wishes are documented, especially in this day and age where more and more we have the medical and legal community moving more towards euthanasia and not valuing life as much. Also in the state of Florida where I practice, we had a nationally known case of Terry Schiavo, where our courts determined, went all the way to our Supreme Court, that food and water can be considered artificially prolonging your death, no different than the machines. We also want to make sure our wishes regarding organ donation are known. These are all just horrible decisions. Nobody wants this job of making those decisions for somebody else. So as an act of stewardship and love to your family, you want to make them aware of what your wishes are, so that if they're called upon to make these decisions for you, they know what you want and they can make sure your wishes are carried out. Another thing you want to consider is a pre-need guardian designation. Where this comes into play is if you become incapacitated. In Florida, we call it the Baker Act. Other states have different names for it. But basically, they take you in for evaluation against your will, and they can hold you for 72 hours. After that, they need your authority or the court's authority to continue to hold you for continued treatment. So the pre-need guardian is anticipating that, and you writing in advance in the form of an affidavit, a letter of your preferences to the judge, letting them know what you want done if and when that were to happen to you. Now, contrary to popular belief, this is usually the shock moment, is many people believe that because they have a will, they will not go through probate. That is absolutely false. Don't believe the fake news. All wills go through probate. Probate simply is the process of transferring your assets from you to your beneficiaries and making sure that before that happens, everybody is informed, everybody gets an inventory, everybody gets an accounting, your creditors get notified and satisfied, and everything is cleaned up and everything is satisfied before whatever is left over, the remainder, goes to your named beneficiaries, which could be people, could also be your favorite charities, but all this will happen after the probate process. In Florida, this process takes 9 months to 2 years on the average, and attorney's fees are 3% of the probate estate, which is not everything, but when you meet with your estate planning attorney, which I recommend you use an attorney instead of these online forms, then you want to find out what probate is going to be in your state and what steps that you can take to avoid it. One of the most common methods to avoid it is the revocable living trust. Now, we still have some administrative process that needs to happen, but instead of an estate administration, we have a trust administration or a shutting down of the trust. Typically, we can do that in 4 to 5 months instead of 9 months to 2 years that we saw with probate, and the trustee can act almost immediately instead of waiting for a court order. For those of you that are high net worth, if your total net estate is approaching close to 15 million, then there are also different types of trusts that we can do for married couple that can double that exemption, where your surviving spouse could shelter up to 30 million, again, either for your beneficiaries or for charity. Another opportunity to do charitable giving here, if your estate would be taxable, then you can reduce your tax burden by naming charities as part of your estate. All of this is not just about money, but it's about preparing the next steward to be wise and to receive a blessing and not a curse. So you may have beneficiaries that have difficulty managing money. For those, or some people say for all, we can make it a requirement that they complete Financial Peace University before they receive their inheritance. We can hold their money in trust. If you have beneficiaries that are special needs and receiving government benefits, then we can also create special testamentary trust or subtrust for them. If your beneficiaries have a drug or alcohol problem, we can structure their money so that they don't just get a check and maybe go out and injure themselves or maybe even kill themselves by overdosing, but instead we can set up the money in a way that protects them. If you're concerned about a possible divorce of one of your beneficiaries, putting the money in trust can protect it from the future divorce from the spouse that may be trying to claim part of your beneficiary's estate. So we also have free resources available to you on our website, lcgiving.org, and you see them listed here. You can get to it on your computer. You can also scan this QR code, but available to you, we just have a wealth of free resources, from a asset summary to a memorial planner to healthcare advance directives that can share your faith to the medical personnel and to your family and friends that would be around your bedside. And also we have a Christian introduction that you can include in your will. And we also have a free estate planning guide which you can request. Thank you so much for joining us. And if you have any needs in the future, you have our phone number and website. Feel free to contact us, and we would be happy to help you with your legacy giving needs. God bless you.